Thank you, Judge.
You're welcome.
Judge, kind of starting where Mr. Filiato started, as it relates to the Beatty case, I just suggest to the court that is advisory. I understand that, but I think the court, as you know, you have plenty of other options here besides adding additional specs where the court has signaled to us that 6 is enough. Having said that, Your Honor, I know that the same thing is true for my client. He would like to exercise his appellate rights. As such, he will say very little here today. And finally, he is an indigent judge, and the court knows that. If you consider that when you apply fines and costs in this matter, to be appreciated. Thanks very much.
Thank you. Mr. Parker, same thing. Your attorneys let me know that he's advised you not to speak. I have to give you the opportunity to say anything that you wish for purposes of the sentencing. Is there anything that you wish to say?
Yes, I would like to speak.
Okay, go ahead, sir.
First off, I'd like to say to the family, if I was a guilty man, I will own up my guilt, especially in the death of a 3-year-old child. I got children of my own. I got 3 daughters and a son, a 1-year-old son to be exact. So I want to say my condolences to y'all. And if people feel that this is justice, if I'm guilty, based on what we were saying, everybody sat through the trial. So you see what I was up against. So I would just like to say my condolences to y'all. And I pray, I keep y'all on my prayers, and I ask that God keep a hand over y'all family. And that He shield y'all with the power of the Holy Spirit. I would like to say that. Amen. That's all I have to say.
Thank you, Mr. Parker. You can have a seat. Okay. I have considered all of the information that's been presented here today. I've reviewed the purposes and principles of sentencing pursuant to Revised Code 29.11. The serious and recidivism factors relevant to these individuals. In this case, pursuant to Revised Code 29.12, and the need for deterrence, incapacitation, rehabilitation, and restitution. But most importantly, I sat through this trial. It was 10 days of testimony, 10 days of evidence. So the facts, I am more than fluent with how we got here today. And this is a separate sentencing hearing. We had a different sentencing hearing this morning for the other 2 co-defendants. But I said something that I think it's important to say it again. The actions here today have stolen the life of a baby. And it will never leave my mind that that little boy, I will probably picture him in my head for the rest of my life, was 42 inches tall. And I do not know why this sticks with me so much, but it's haunting because he was so tall. And we never are going to find out how tall this little boy was going to be because his life was stolen from him. He's never going to grow up. We are never going to see how tall he was going to be. He's never going to get a driver's license. He's never going to fall in love and have the opportunity to have his own kids. And that is heartbreaking. And I think it's important that I say it twice because this is a separate hearing. Now, I don't disagree, Mr. McNeil, with what you talked about the problems plaguing our society, but I need to point out that I'm well aware of Mr. Davis's diagnosis. He was placed on, he's the reason that this case is on my docket because I'm a mental health court judge. That's why I have this case. And immediately upon getting his first case, I put supportive services in place. He has had the supportive services of the mental health docket in the past. The court has attempted to address all of the issues that we were talking about, and they just did not work. He was on court supervised release with the monitor when this happened. So while I agree with you, I'm done giving the chances to Mr. Davis. Okay, for both individuals, I agree with the mergers that were placed on the record by the state of Ohio, and further, I am going to sentence only on 2 of the firearm specifications. I am required to sentence on at least 2 of those to be served consecutively. I will not sentence any further on those firearm specifications. For Mr. Davis, the firearm specifications, you have 54 months, 3 years, 18 months, and 1 year. They all merge to the 54-month firearm specification. I'm sentencing you to that 54-month firearm specification in count 3 and count 10. And those run consecutively. They are required by law to be run consecutively. So that's 9 years of mandatory firearm specification time. This firearm specification time will be served prior to and consecutive to the underlying sentence for count 3, which is life with the possibility of parole after 15 years. Further, I've been a judge. I'm in my 11th year. I've never once imposed repeat violent offender specification time. If ever a case deserved that time, it is this case. I am finding that the offense here, count 3, is the offense of murder. I have imposed the longest prison term for the offense. I'm finding that the prison terms under subsection B2A, subsection 3, are inadequate to punish and protect the public from future crime under Revised Code 29.12, and that the prison terms under that same subsection above are demeaning to the seriousness of the offense because one or more factors under Revised Code 29.12 indicate that Mr. Davis's conduct is more serious than conduct normally constituting the offense. And they outweigh all the factors indicating Mr. Davis's conduct is less serious than conduct normally constituting the offense. I'm adding 10 years to the sentence on count 3. Count 10 is the qualifying offense. And I have already imposed the 54-month firearm specification time for that charge. That will be served prior to and consecutive to the indefinite sentence of 10 to 15 years in prison. The sentence for count 7 and count 12 are each 5 years in prison. And the sentence for count 17 is 3 years in prison. So adding all of further, I am finding that consecutive sentences are necessary and warranted in this case. I'm ordering Mr. Davis to serve the sentences on counts 3, 7, and 10 consecutively. After reviewing the record and the evidence, I find that consecutive sentences are necessary to punish Mr. Davis, to protect the public from future crime, and are not disproportionate to the conduct or danger posed by Mr. Davis. And I can find all 3 subsections that apply in this case. I only need to find one. Mr. Davis's criminal history demonstrates that consecutive sentences are necessary to protect the public. I can also find that Mr. Davis's offenses are part of a course of conduct and that the harm caused was so great, meaning the loss of life of that little boy, that a single prison term would not adequately reflect on the seriousness of the conduct. And lastly, that Mr. Davis was on court-supervised release and under the supervision of the probation department when this offense happened. Counts 12 and 17 will run concurrent. Adding all of that up, the sentence for Mr. Davis is life with the possibility of parole after 49 years. Please be quiet. I apologize. I'm doing that respectfully. Mr. Parker, you have firearm specifications 3 years and 1. They merge, and I am only going to sentence you on the 3-year firearm specifications for counts 3 and 10. I am required to sentence you on those terms consecutively, so you will serve 6 years for the firearm specification on counts 3 and 10. That firearm specification time will be served consecutive to the sentence for count 3, which is life with the possibility of parole after 15 years. I'm also going to order the repeat violent offender specification, finding that this is an offense of murder. I've imposed the longest prison term for this offense, and I find that the prison terms under subsection B2A3 or I are inadequate to punish the offender and to protect the public from future crime under Revised Code 2929.12, and that the prison terms under that same subsection are demeaning to the seriousness of the offense because one or more factors under Revised Code 2929.12 indicate that Mr. Parker's conduct is more serious than conduct normally constituting the offense and outweigh all factors indicating the offender's conduct is less serious than conduct normally constituting the offense. I'm ordering 10 years of repeat violent offender specification time. Count 10, I've already imposed the 3-year firearm specification. This is the qualifying offense, so that firearm specification time will run prior to and consecutive to the indefinite sentence of 10 to 15 years in prison. The sentence for count 7 and 12 are each 5 years in prison, and the sentence for count 18 is 3 years. I'm further finding that consecutive sentences are warranted, and I'm ordering Mr. Parker to serve the sentences in counts 3, 7, 10, and 18 consecutively. After reviewing the record and the evidence, I find that consecutive sentences are necessary to punish, to protect the public from future crime, and are not disproportionate to the conduct or danger posed by Mr. Parker. I'm also finding that Mr. Parker's criminal history demonstrates that consecutive sentences are necessary to protect the public, and that Mr. Parker committed these offenses while on post-release control. Count 12 or 1 concurrent for a total prison sentence of life with the possibility of parole after 49 years. As it relates to the qualifying offenses, when it is presumed that you will be first of all, let me go back. When you have your firearm specification time, that's mandatory sentences. That means that you're not eligible for good time credit. But once you finish your firearm specification time, it is possible for you to earn good time credit, and that ranges anywhere from 5 to 15%, and that is for good behavior. I have the right to deny your good time credit, but before that could happen, I would assign an attorney to represent you, and we would conduct a hearing. As it relates to these qualifying offenses, you will be released when you finish your minimum term, unless the Ohio Department of Rehabilitations and Corrections determines that you must remain in prison for bad conduct. That decision is made by the Ohio Department of Rehabilitations and Corrections. If you are not released when your minimum term ends, you will serve an additional specified period of time and be given a new release date. You will be released on that date unless you are again denied release for bad conduct. This process repeats until you are either released or until you finish your maximum term. When you are finished serving your prison sentence, the State of Ohio Adult Parole Authority will have a mandatory period of supervision. It's post-release control. For both of you, it's a minimum of 2 years, up to a maximum of 5 years. If you fail to comply with the terms of any post-release control supervision, the Adult Parole Authority could modify or extend your supervision and make it more restrictive. They could incarcerate you for up to half of the sentence I've imposed here today. It could charge you with a new offense called escape, another felony where you would face additional prison time. And if you commit a new crime while on post-release control, you could face the maximum penalties under the law for that new crime committed. Mr. Davis, you have 508 days of jail credit. Mr. Parker, you have 505 days of jail credit. That will go towards the sentence I've just imposed once you finish the firearm specification time. For both of you, I am finding that you are indigent and I'll waive the fines and court costs associated with your cases. To each of you, you have an automatic right to appeal your judgment of conviction. You have a right to have a notice of appeal timely filed on your behalf. I'm finding both of you indigent, and I will appoint counsel to represent you on appeal and provide a transcript of all the proceedings in this matter at the state's expense. Mr. Davis, I'm appointing Joe Pagano to represent you. Mr. Parker, I'm appointing Jay Schlackett to represent you on appeal. Mr. Filiatro, do you have a response to Mr. Davis's request for vehicle releases? Or would you like to address that at another time?
If I could address that separately, I'd appreciate it. Thank you.
That is not a problem. We'll hold off on that matter. We'll get a separate issue. We'll get a separate ruling at a later time. Anything further on behalf of your client, Mr. McNeil?
Nothing further, Your Honor.
Thank you. Mr. Spellacy?
No, thank you, Judge.
Thank you. And on behalf of the state of Ohio?
No, Judge, thank you.
Thank you. We are adjourned.